afternoon. My name is Attorney Devin Shanley with Peterson Burke and Cross, and I'm here with you for another edition of Lunch with a Lawyer. Today's topic is a lawyer really needed for an estate plan? We'll be spending some time talking about that. I know it's always funny to hear lawyers talk about if lawyers are really necessary, but we're going to be talking about that, how some simple steps that you can do probably right now, maybe you've already done, to form an estate plan that don't require a lawyer at all, and where the lawyer is going to be valuable and needed in forming a proper comprehensive estate plan for you. Before we get started, a few of the disclaimers that regular viewers probably know about. First of all, we at Peterson Burke and Cross are a law firm based in the great state of Wisconsin. So if you are in Wisconsin, thank you for joining. And this law is going to be applicable to you. If you're not in the state of Wisconsin, then, well, first of all, thank you for joining. Second, some of this law may be applicable to you, it may not. So I advise you talk to a lawyer in your local area to find out how this applies specifically for you. If you do have a specific question of law in the state of Wisconsin and you would like to have a more thorough legal opinion on the matter, please give us a call at Peterson Burke and Cross at 920-831-0300, or contact us through the Facebook page, or contact us through our website, or email us. I suppose you could just show up in person, but it's better to contact us ahead of time and set up a consultation with one of our attorneys here, where we can talk about the legal issues that you are facing so that we can give you the best legal advice possible, do our proper conflict checks, and really start to see if an attorney-client relationship is best to be formed. As for what we're going to be talking about today, I'm only going to be talking about generals with the law, hypotheticals, and have this purely about educating a mass audience about the law. I am not going to give specific legal advice on any particular issue. If you ask a question in the comments about specific questions, I'm going to rephrase that and remind people to schedule a consultation with myself and one of the other attorneys here, because we do not intend to form an attorney-client relationship with anyone. I also, before we get started, want to give a special shout out to the Four-Way Bar and Grill in Swamico, Wisconsin, who have generously provided lunch and are sponsoring this event. I actually got to go and pick that up today. It was fantastic. It's a beautiful bar in an outdoor setting, perfect for our current conditions today, both with weather and with the desire to kind of sit more outside when we dine in at restaurants. And fantastic little location. I ordered the bluegill platter, which you can see right here. I even helped myself a little bit to it, as you can see. Great food. I always love it when I can find something beyond just, cod or perch, and find a nice like bluegill or a different sort of fish. They also have a wide sort of menu to be able to adjust for any one of your needs. I might actually try and convince my wife to head there tomorrow because, like most Green Bay natives, on Fridays I tend to think fish and fish fries, and this is a very, very good one. So remember that this weekend as you're going out, the Four-Way Bar and Grill in Swamico, Wisconsin. Thank you again for sponsoring. So, is a lawyer necessary to form an estate plan? The short answer is, well, no, but you probably still want one. I always get uncomfortable when people look at me and they say, Devin, do I really need a lawyer? And I always flash back and I often tell the same story. And it goes something like this. I was 20 years old and I hadn't ever really been to the eye doctor. So I thought to myself, I should probably go to the eye doctor. So I scheduled an appointment. I was seen generally fine. No one had told me that I was blind, at least not in a very serious way. But I thought it would be a good idea to get a checkup. So I called the person that my parents went to, and I went and I got checked up. And I remember the doctor dilated my eyes, and I sat down, and he said, well, and then he told me a joke. He said, you know what they always say about eye doctors? I said, no, what? He said, they're always trying to hang glasses on people. He then proceeded to tell me why exactly I needed glasses, and I wasn't really convinced. The appointment ended. They tried to sell me some glasses, and I walked out, and he actually didn't give me the sort of wraparound, like, protective eyewear after they dilate your eyes. So I drove home with my eyes dilated, and it was really weird. And I really wasn't impressed. And I never went back to an eye doctor again for another 10 years until I was in law school. And then they're like, well, you probably could use a little bit. And now I wear these glasses that you see today. Um, the moral of the story is a lot of times professionals will tell you that you are absolutely needed when you may or may not really need them. And this is something that I'm very sensitive to when people say, Devin, do I really need a lawyer? One of the interesting things about being in Wisconsin is there's a lot of standardized forms for a lot of really common court areas, and the state really does try to make an effort to supplement people who are going to be what lawyers call pro se. Does that mean that it's wise to represent yourself? Probably not. Lawyers do have jobs for a reason. Most lawyers are really, really good, and they're able to use their proficiency with the law to not adequately, but to effectively advocate for their clients' positions. In estate planning, that advocacy, that showing up in court and looking great in a suit and saying a bunch of fancy things, takes on a different role. Instead, it's one of trying to educate, trying to get people to form an effective plan. It's a lot of interactions with the individual and setting their plan up for success using the legal documents that you have available to you. And so there's definitely value with having an attorney. But is an attorney absolutely necessary? And I think the interesting answer here is no, but there are a few areas where an attorney is going to be necessary for a few specific documents. Let's talk about that. When most people walk into my office and they sit down with me, we cover goals. And the most common answer I get when I talk about the goals that they're trying to go accomplish through the estate planning process is going to be avoiding probate. There's going to be a couple others. I want to get my affairs in order. I don't want there to be a lot of fighting amongst the kids. I want to avoid estate taxes. But the big thing that a lot of people really come across these days is probate, because probate is scary and people really are trained to want to avoid it. And oftentimes that's a good instinct, sometimes not, and we talk through that. When we talk about just basic probate avoidance, that can be done in a lot of different ways. In fact, it's probably done with something that you've already done now and you didn't even realize it. I'm talking about something called beneficiary statuses, or what I refer to as pay on death designations. So for example, you sit down with your financial planner or the HR person comes into work and they talk about that annual meeting with the 401k, and your eyes glaze over because you want to get back to work and they're talking about the 401k. Or you sit down with your financial advisor and they're going through all of your accounts, and inevitably the HR person or your financial advisor gets to this part and go, and when you die, who do you want to give this to? And you kind of say, you scribble out a name and then you give it back to them. Congratulations, you've just done estate planning. And you've probably done estate planning with an asset that may be one of the most valuable assets in your estate. A lot of times people have most of their wealth these days wrapped up in IRAs, inside of mutual funds, maybe with life insurance, and their home, also their cash bank accounts. In fact, if I took all of those things together, for most middle-class Americans, that's probably going to be the majority of their estate. We might think of wealth as our cars or the stuff in our home, but really it's those monies in accounts, it's that land, that's really going to drive most of the value that we have. And most of that stuff, you're going to be able to put a pay on death designation on that, or a beneficiary, or note for someone to take it after you've gone, just by talking with your financial advisor, your banker, an HR representative, any number of areas that are not specifically a lawyer. That's fine, that's great, and that's definitely an evolution in the law to make the process simpler and easier for people to transfer their wealth. The problem is your financial advisor may or may not have a total global picture of what you want to have happen after you die. You might not even be thinking about it in that moment, especially if we're talking about the HR person at work just coming in and signing a bunch of papers. You might not be thinking, well, I want this money to go here, and I want this money to go there, and I want this to cover this degree. And you might not even realize that designation, that payment, doesn't account for what is in your will. And so there's this lack of holistic approach that can create problems. A very common phone call that I get is something from a distrustworthy beneficiary calling me up and saying, you know, my Uncle Jack died, and Uncle Jack's will left me some significant piece of money, and now they're saying that there isn't money in the estate to pay it, and I don't trust my cousin Frank, who's telling me this, and I think he's really trying to swindle me. At that point, well, I suppose Frank could be right, or it could be that Uncle Jack made the note in his will thinking, I've got so much money in my IRA, of course my will can cover that. And then without thinking about it, when he was sitting down with his financial advisor, said, of course I want my IRA to go to Frank because he's my kid and that's the way I want it to be. And now suddenly the will doesn't have the money to give out this large cash to the potential client. And it'd be very difficult to track down and sort through some of that stuff in a very effective manner. This can cause problems and can cause strife without you even intending it. Ultimately, the best way of thinking about these things is by looking at the role of the attorney and taking that step back and advising people across the whole of what they have. The attorney is going to have the luxury of being able to look at all of these sorts of resources and be able to draft documents, ask questions, and be able to give a comprehensive plan to help you form that. That's going to be a little bit better than going piecemeal by having these individual beneficiary statuses where the individual advisors might not even be talking to one another. Your bank, who's setting up the PODs on your bank accounts, your checking account, your savings account, might not even know who your financial advisor is or might not know that you even have this IRA that's worth a certain amount of money. They might not know about the specific cares that you want to leave for specific beneficiaries. The other problem with going on a non-lawyer estate plan is going to be a question of validity versus effectiveness. This is going to go beyond just the basic things that you can do on your own, setting up your own pay on death designations, or setting up what's called joint ownership in property. Joint ownership in property is when you co-own a piece of property with another person, and it's set up in a way that when one of the joint owners dies, the other just automatically takes what's left over. That can be done on a joint checking account. That can be done with real estate as well. And again, when you're setting this up, that might not be something that you talk about with an attorney. That might not be a concept that's really discussed when they just put names on accounts or just put names on deeds. So it's going to be it's going to be a valid transfer, but is it going to be an effective one? The other area where I see this is when people decide to just start drafting documents on their own. Is it possible to draft a will without an attorney? Yes. Yes, it is. It's effective to, is it possible to draft a power of attorney without an attorney? Yes. Yes, it is. The state of Wisconsin actually offers what are called statutory forms for a power of attorney for finances and a power of attorney for healthcare. You can get these for free from any number of places, and they're very, very easy to fill out. Then they're a valid power of attorney. But they might not be effective. There might be twists inside of the documents that you don't fill in quite right. There might be areas where you're a little ambiguous with your terms. Wills can get pretty specific, and if you just say something to the effect of, well, I want to give to my son Johnny the ability to live in my house until the day I die, or until the day he dies, and I want my estate to pay for it. Well, that might be a really difficult transfer to make happen, because then you're either having your probate estate stay open until Johnny dies, which really isn't a great plan, or you might need to transfer something called a life estate to Johnny, but then Johnny's going to be responsible for the costs, which is not necessarily what you put into that. and that might not be totally what Johnny is capable of doing. Uh, and so it's going to be difficult to really get some of these wordings right, or to be able to think through exactly how that's going to play out after you die. Having an attorney to advise, talk through the process, talk through the methods that you could have this Johnny enjoy the benefit of that house, or talk through the strategies of turning that over to him is going to be important. And then using a full range of legal tools to be able to accomplish that goal is going to be best. The person who's going to be best able to offer that full range of planning and effectiveness is going to be an attorney, because they're going to be able to draft documents, talk about ownership strategies, and have an understanding of that to be able to set that up. Just because a will is valid doesn't necessarily mean it's going to be the right effective solution. And an ineffective will can cause as many problems as an invalid one. So what exactly is an attorney going to do? And I've mentioned this a little bit, but I want to drill down deeper and get at this specifically. First, you're going to want to look at situations that only an attorney is going to be able to help you with. This is probably going to revolve around something called incapacity. Incapacity is when something happens to you, but you don't die. This is a secret that I mention to people. People have been dying for a very long time. A lot of these laws that we have are old, and as a result, we tend to know what people want to have happen with their belongings after they die, whether or not they've formed a will. The assumptions that are put into place are right for most of the population. Not all, but most. What we don't know is, who do you trust to be able to take care of you? What we don't have an efficient, automatic thing for is taking rights away from people so they can't continue to hurt themselves or others, and placing that with a trusted individual. That process is typically something called a guardianship, except in really extreme cases. But for now, let's just talk about this in the way of a guardianship. If we have an adult who cannot function, they cannot take care of themselves, they cannot manage money, and allowing them to continue to do so could be detrimental to them, then we would have a guardianship hearing to take those rights away. That's a fairly intrusive prospect. Instead, there's alternative documents that allow the person to retain some rights, but still allow another person to share them, and that's called a power of attorney. There have been a couple other Lunch with Lawyers that have that, so I'll save you to watch. I'll let you watch those to see the real nit and grit and the specifics of that. But power of attorney documents are going to be best drafted by an attorney. You're going to want to make sure that you're giving the right powers, that you're going to be robust, that they're signed properly, so that they can be as comprehensive as possible. If a power of attorney fails, that means it's going to be a guardianship to fill in the gaps that the power of attorney missed. And you're going to want to know what are the limits that we can have, while at the same time being appropriate for you. A very common power that's often thrown in, but that you may or may not want, is the power of gifting. Can an agent give gifts? This might seem obvious at first, but it actually works out to be a fairly difficult decision. Do you want to be able to have your agent, if you're incapacitated, give your Christmas gifts every year? Do you want to limit them and not to be able to give everything away? Maybe you do need them to give everything away for some reason. How does that happen? And if we don't make a decision, if we don't have that discussion, then it's going to be difficult to guide the agent when you can't guide them yourself at that time. The other thing is going to be, how do we have an agent come into power? Do we want them to be able to do this right now? You just want them to be able to act? Or do you want to do it all yourself until you can't? And then the definition of can't becomes very important. Longtime viewers know I often grouse about the show Tiger King, because Tiger King has a specific triggering clause inside of its power of attorney about disappearance. This was used as some sort of example of it being very unusual. It's not, but that's an example of a triggering event. If the person disappears, then the power of attorney comes into place. The powers vest, and the agent can act on behalf of the principal. These are discussions that it's best to have with an attorney to make sure that you have a document that reflects your wishes and something that you are comfortable with. And it's going to be something that's going to be difficult to have if you're just trying to draft this yourself with some sort of standardized form, or if you're just working on a computer program, something akin to, TurboTax. That's going to be a very nuanced conversation that having an attorney to guide you is going to be good. Another area where having an attorney is going to be good is when you have difficult property to give. It is very, very easy to put a transfer on death on a bank account or on a mutual fund account or on an IRA. It's a lot harder to do that with the gold bars buried in your basement. It's very tough to do that with, say, a tractor or the Monet sitting in your foyer. Depending upon what sort of valuable personal property you have, that could be a lot trickier. So if you have an estate where you just have a lot of equipment because of what you do or because of what you like to collect, then having a more thorough estate plan drafted with an attorney, maybe even using a trust, might be a more effective way of accomplishing your goals. This would also be something similar with a business. It's very easy to put a transfer on death on shares of Disney because you're probably working through some sort of brokerage for that, and they probably have methods to be able to handle that. It's a lot harder than if you own just the corner drugstore and it's just something that you've built from scratch. Then there really isn't a simple transfer on death tool that you can use for that, and you'll probably want to look at how you can maintain succession inside of your business, how to transfer those shares, how to do that effectively and privately so to not stress the business, but also make sure that your hard work is rewarded and the people that you love are compensated for the business that you built. That is going to be a lot more complicated estate planning rather than just saying, well, Susie gets the life insurance or Jolene gets the 401k when I die. Difficult beneficiaries are also going to be something you're going to want to talk to an attorney about, and I've kind of hinted at this before. What you have to understand about most non-probate transfers and most of these ways that you can simply set things up without an attorney is going to revolve around what I would refer to as outright transfers. Meaning it's something akin to this. Here you go, take this money, don't spend it all on candy, and that's really about it. What you have to understand is once people get the money, then it's their money. We can't really put any restrictions upon how they spend it. If they want to be foolish, they can be foolish. It's very common for me to hear people say, well, Dad never intended the money to be used like that. Well, that might be true, but here's the secret. Dad's dead. That's why you have this property to begin with. Or maybe Dad isn't dead, but he's given it to you. He might not give you any more money or any more property, but if he doesn't have anything more to give, then that wasn't going to happen anyways. And if you can sleep at night not following through with his wishes, then you can still do it and sleep at night. Moral of the story is, if you have difficult beneficiaries, if you need to manage that money in a way that protects them and puts conditions on, then you're going to need something more robust than a basic non-probate transfer or language that you're going to be able to write yourself. Talking with an attorney to talk about how to structure those gifts and what are going to be ways that you can limit access but still allow that beneficiary the ability to gain some of that gift is going to be absolutely critical, and the attorney's advice is going to be extremely helpful in that. It's also if you have somebody where you have a special needs trust or someone who legally couldn't own money, otherwise they might have some sort of benefits lost. That's going to be a very specific form of estate planning. You are absolutely going to want to talk with people who know how to structure those gifts and be able to allow the person to allow the special needs individual to keep their benefits but enjoy the gift that you've intended for them. The last is going to be general emergency situations. I've had more than one client, when I walk through the loss of intestacy, when I walk through non-probate transfers, they look at me and say, but Devin, why do I need a will? I mean, if that's it and I'm good with that and I'm fine with intestacy, do I really even need a will? And usually what I say at this point is, well, no, but probably. A will is going to be a great tool to handle emergency or unforeseen situations. I liken it to a net for a trapeze performer. It's there if you need it, but if you don't, that's okay too. Now, in a trapeze act, they work without a net, but here's the secret. They've practiced. They know that wire, they have all the conditions under control, they've predicted everything, and they know that they can do it. I don't think you're going to rehearse your death and how to transfer your assets afterward, and we probably don't know the conditions upon which you die and who's alive at the time when that happens. That's generally not something we know. So having as many safeguards in place is going to be critical to make sure that your wishes are known. Usually inside of a will, this is something called ancillary beneficiaries or remote contingent beneficiaries. Basically saying if the will runs out of people to give money to, then the money goes here. That way you can still control it. You still control who comes in and takes control of the possessions. Or if there was something that you didn't account for owning that you didn't get a non-probate transfer on, then you can still allow for that direction to occur. A good example of this is if you buy a cottage. If you buy a cottage somewhere in this great state, you may or may not do the necessary steps to transfer that easily upon your death, such as putting it into a trust or putting a transfer on death deed on it right away. You might just be happy that you bought a trust and you want to enjoy it. If you die before you put the non-probate transfers into place on that, you can have everything set up to avoid probate, but then this one asset that you forgot about is going to cause problems and going to force probate. If you don't have a will set up, then you're not going to really guide who's going to be in charge of that, who's going to be getting what. You'll just be having whatever the law and the courts give you and your beneficiaries. That may or may not fit with what you want. As always, anytime you're going to be thinking about hiring a lawyer, you've got to think about who do you trust, who do you have a good relationship with, and who is going to give me the best advice that I can rely upon. Now, that's why we give a free consultation so you can get to know the attorney that you'll be working with, get to ask questions, learn more about the law, learn more about the options that you have, and be able to start to build that essential rapport. Estate planning is done more and more these days without lawyers. That's not necessarily a bad thing, but still having somebody advise you and set up the areas that are going to be something very specialized for an attorney is going to be critical. If you have questions like this, if you haven't done any planning, please contact us at Peterson Brook and Cross so we can set up an initial consultation and help you form and fill in the gaps in your plan and really tie everything together so it is one comprehensive plan. We do this at Peterson Brook and Cross because we're specializing.